Before we begin, we'd like to give special thanks to all of our sponsors for making this event possible each year. Specifically, thank you to CRL FormFox for being our title sponsor for 6 consecutive years. And thank you to our platinum sponsors, Psychmedics, OraSure Technologies, Quest Diagnostics, and Veriforce. Hello, and thank you so much for joining us for another session of Day with DISA. Today, we'll be focused on drug testing and specifically marijuana legislation. We're joined by Jennifer Mora, Senior Counsel at Seyfarth Shaw. Jen, how are you doing today?
I'm great. Thank you for having me.
Yeah, we're excited to have you. And before we jump into your presentation, a couple of housekeeping notes. If you have any questions during this presentation, use the Q&A button at the bottom right of the player. If we're unable to answer today, we'll reach back out to you next week after the conference. Additionally, we're going to make a copy of this presentation available for download in the Materials tab at the end of this session. With that being said, Jen, the floor is yours.
Well, great. Thank you for having me, and we will go ahead and get started. Before I begin, I'll just tell you a little bit about myself. I'm Senior Counsel at Seyfarth Shaw in San Francisco. I advise regularly on background screening issues, and also in the last almost decade, I've developed an expertise in drug testing and marijuana legislation. Before I do get started, I just want to remind everybody that this presentation is for informational purposes only. Nothing that I say today should be considered legal advice. There are differing opinions out there on this subject, so please don't take anything I say as gospel. This is just my view, but definitely reach out to me if you have any questions. So just to kind of tee things up, this slide shows, we've seen this explosion of medical and recreational marijuana laws being passed all over the country. It's really picked up in the last couple of years. I think every year we see more and more laws, both on the medicinal side and the recreational side, being passed. This slide sets out the jurisdictions that currently authorize medical use. And when I say medical use, I'm focusing solely on medical marijuana. I don't typically track the CBD laws. So I think there's a couple that are not on here that have legalized CBD for medicinal use. The jurisdictions that are in bold and underline, those are jurisdictions that we believe are applicant or employee friendly, for lack of a better term, meaning that either the statute or a case has come out that specifically provides employment protections for medicinal users, whether they're job applicants or current employees. There are 5 jurisdictions up here with an asterisk after the title. So Arkansas, Missouri, Montana, New Mexico, and West Virginia, and Oklahoma. So I think that's actually 6 now. So you can see how fast these laws change. So 6 jurisdictions with the asterisks. They do have employment protections for applicants and employees. However, based on the way the statute is written, we believe that in these jurisdictions, there is an exception, or what we would say is a reliable, safety-sensitive safe harbor, which means that if you're in any of these 6 jurisdictions and you are testing and then somebody says, well, I use medicinally, you don't have to provide the employment protections to those people if they work in a safety-sensitive role. I will say that there are, I think it's Oklahoma or maybe Arkansas. One of them is very clear that in order to take advantage of that safe harbor exception or benefit, you have to make sure that you've advised the applicant or employee in advance that they work in a safety-sensitive role. And to be quite frank, that's something that I suggest that you do in all jurisdictions anyway. If you want to make sure that somebody is in a safety-sensitive position and you're going to take advantage of any sort of benefit to you if they work in that type of role, it's always a good idea to tell them that in advance so that they know as well. I would say in the last 2 years, I think this list has doubled. We've really seen the number of jurisdictions that have passed laws legalizing recreational adult use. So this is the current lay of the land. South Dakota, just move this bar. South Dakota is the one with the asterisk, and that's the one that says that the state had held that one unconstitutional. We'll talk about those that are employee or applicant friendly. Most of these are still, an employer can have drug testing policies or zero tolerance policies in most of these jurisdictions, but there are a couple that I'm going to discuss. And so those are those. Oh, and I want to clarify that this does not include decriminalization only jurisdictions. So those are states where the state has specifically decriminalized but hasn't necessarily legalized. The difference is that if something is legal, then it's legal essentially for all purposes, provided that you don't have too much, or you're a certain age, or you're not using, on public transportation, things like that. Decriminalization simply means that law enforcement and prosecutors take a hands-off approach. They're not going to prosecute people who are busted for simple possession, but that doesn't necessarily mean that it's legal. So there may be some states that are not on here, and those would be decriminalization only jurisdictions. So I do want to talk about New York. The law is 2 years old. However, actually more than 2 years old at this point, almost 3 years old. However, I do want to highlight it again because it's really, as far as I'm concerned, the most restrictive jurisdiction in the country in terms of an employer's ability to take any action against somebody who uses marijuana there. And the reason why is that the state amended its off-duty products law to specifically include cannabis. So in off-duty products law, if you think about, there was a time when employers may have been discriminating against tobacco users. And so some states had passed laws saying you can't take action or discriminate against somebody because your employees are doing things outside of work or using products outside of work that are legal. There's been some kind of tension in some of the states around the country as to whether or not the laws apply to marijuana now. Colorado and Nevada have both said that their off-duty products laws don't protect marijuana because of the way the laws were written. What New York did is they actually did something that we'll talk about. Montana did the similar thing, which is to amend the existing off-duty products law to specifically include cannabis. The problem is that the DOL, the New York DOL, then kind of looked at that and decided that they were going to put out an FAQ. It's about 2 or 3 page FAQ where they're very explicit that they essentially said that employers can't test, period, and a discussion unless there's very, very narrow exceptions that apply. One of those would be regulated roles. So you can imagine DOT drivers or any employee or applicant who's trying to work or does work in a position where there's a federal mandate requiring testing. Or if the employer is a government contractor, but the government contract, there's got to be some risk that the employer could lose the government funding. So you can't just say, well, I'm a government contractor and therefore I can test, because the Drug-Free Workplace Act doesn't speak to drug testing, and I'll talk a little bit about that. So the exceptions are extremely narrow in New York. There's no exception for safety-sensitive roles, again, unless they're regulated. So, do I necessarily agree with the statute? Not the DOL's reading of the statute, not particularly. However, I think there's great risk right now in New York to do any cannabis testing, even reasonable suspicion, unless the employee is trying to work or does work in a regulated role. One of the big changes that happened this year, and it's effective January 1, 2024, is that in California, which was always a company employer-friendly jurisdiction for 2 decades, I think, since they passed their medicinal law, but they were really sort of behind in this space, and I was surprised it took them this long. But long story short, in California now, cannabis users are essentially a protected class, and I say that because the California Civil Rights Division, which used to be the California Fair Housing and Employment Department, oversees the Fair Employment and Housing Act. And the legislature here put AB 2188, these protections for cannabis users, in the same section of the California law that protects people based on their race, gender, disability, things like that. And somebody who is discriminated against, for lack of a better term, based on their cannabis use off duty and away from the workplace can potentially obtain the same remedies that somebody who, for example, has been sexually harassed at work or harassed because of their national origin can obtain. So the way the California law is written, and it's unfortunate the state decided to put some text in their findings, made some assumptions that are just not consistent with the science. What the California legislature wrote in the findings was, we're going to protect people who use this lawful product, in their homes, away from the workplace. And the reason they did this is because they said in the findings, there are currently tests out there that prove impairment. And that's just not true. And so when you look at the statute, which I have up here on the screen, it essentially requires that the employer, and I'll move to the next slide that goes through this, get away from urine tests because employers can't now take action against an employee based on a non-psychoactive test that reveals just the metabolites. So the only test out there, at least that I'm aware of, and I'm sure a lot of labs are working on something different, would be an oral fluids test. The problem is that an oral fluids test only tells you that somebody is used recently. And so in my view, since there are off-duty protections, right, and there's no test that proves impairment, there's risk of even taking action against a current employee in California if you have reasonable suspicion, for example. So employers are having a really hard time figuring out what they're going to do with this. There's no exception for safety-sensitive roles. My recommendation is California employers at least get their methodology correctly, which is to switch to oral fluids. The statute, for whatever reason, decided you can take action against job applicants, so long as you get your methodology correct. But the hard part is going to be dealing with those current employees for reasonable suspicion or post-accident. Other jurisdictions that have some that I consider to be applicant or employee friendly, and there's others, but these are kind of the more recent ones, which is New Jersey. New Jersey has been out for several years. We're sort of all waiting to figure out what's going to happen. If you know anything about New Jersey, they said employers can't do reasonable suspicion unless they get a wire, which is somebody in your organization who is a workplace impairment recognition expert. And this is a person who has to be trained and, in how to detect impairment. And we're still waiting for regulations from the state. But in my view, again, no safety sensitive exceptions there. So I kind of tend to put New Jersey close to New York on the spectrum of what employers can and can't do, because again, that law also protects off-duty use. And so that's one where you're really going to have to work with your outside counsel to figure out how you're going to deal with New Jersey. Washington, D.C. is new. Fortunately, it does have a safety-sensitive exception. So as long as you're at least testing only for those people, then you're probably going to be okay, but it is a long, complicated law, and there are some notice requirements in there. And then Minnesota is another recent one that came down, and that essentially removed cannabis from the definition of illegal drugs in the drug testing statute, but then set out the types of positions where an employer can test for cannabis, and it's going to depend on, are they safety sensitive, are they regulated, is it pre-employment, is it during employment, things like that. So Minnesota is the one place where I would suggest that you at least revise your policy because of the way in which illegal drugs now is defined to exclude cannabis. So a lot of clients ask me, and I wrote an article a couple years ago, should we continue to test? What should we do? And that question really came about because Amazon had made the news saying that they were going to discontinue pre-employment cannabis testing for warehouse positions. They were going to keep reasonable suspicion and post-accident. So a lot of companies called, and they were calling all their lawyers. Should we do the same? What should we do? And so what I wanted to do is just take a quick moment to go through sort of considerations, right? If you're thinking about doing that, and I'm not suggesting you need to or should, that's obviously a business decision to make, but here are the things that you and your stakeholders, the people, the team you should get together, can talk about to decide whether or not this is right for you. So What does a positive test result tell you? Well, we know it doesn't tell you that somebody is impaired. All it tells you is somebody is used in the past, and depending on your methodology, whether it's urine or hair or saliva, it might just tell you recent use. It might tell you not recent use, but at least we know if it's urine, it's sometime, it was sometime maybe in the last couple of weeks. So what does it even tell you, and can you even test? Again, if you're in New York and they're not in a regulated role and there's no risk of losing government funding, then you probably can't test anyway. And, you know, there are some other places, New York City and Philadelphia have ordinances. New York City has basically been swallowed up by the state version anyway. And then you have California and Washington to think about. I do suggest that you at least consider making sure that you have a very strong and defensible reasonable suspicion testing policy. I think the trend is that what I'm seeing is that more and more employers are dropping pre-employment cannabis testing, but they're definitely doing pre-employment, at least in the places where they can, which is most places. But, you know, particularly in California, where it's risky to even rely on a test result, positive test result for a current employee, your reasonable suspicion testing program is going to become even more important, because if you really believe somebody is under the influence at work or impaired at work, and you have concerns about relying on a test because you don't want an agency charge, then you better make sure that you've got, you know, your documentation, your training, train your managers, have two managers or another witness see the same thing that you're seeing. That way that if you do take action against somebody, you can then defend in the event there's litigation. DOT regulated employers, nothing's changed. They're still subject, or anybody who's a DOT regulated employee performing safety sensitive DOT duties, they are subject to the DOT rules. Now, I will say, DOT doesn't say what you do to somebody ultimately if they test positive for marijuana. All it says is that you have to remove them for safety sensitive jobs. If there are other jobs available to somebody, let's say, for example, they're in, the job is in New York where there is no safety sensitive exception, New York would probably say, well, yeah, take them off safety sensitive duties, but if there are other jobs they can perform, then you may have to consider them for their jobs. So keep in mind, DOT doesn't require that you fire somebody simply because they test positive for marijuana, but if somebody is a DOT worker, they definitely are still subject to the DOT requirements. Again, I already talked about reasonable suspicion. Train your managers. I mean, there's a certain deck you can put together. And look, you know, a lot of what I'm saying too isn't necessarily just with respect to cannabis. Train them on what heroin use looks like, what methamphetamine use looks like, what cocaine use looks like, all those things. Because it's not that people are just using cannabis. We're seeing, you know, on the news, fentanyl and opioids and things like that. So what does that look like? How do people present? What do they talk like? What does the drug look like? Sometimes you find drugs at work. What does that look like? So make sure that you're training your managers, focusing on objective evidence. Your opinions don't matter. Your subjective feelings and emotions don't matter. Focus on the objective evidence that you can defend if there is a lawsuit. If somebody is caught using or possessing at work, I don't know if there's necessarily any utility in sending them to the test. I mean, if you search somebody's purse during lunch because you have suspicion and you find a bag of dope in there, fire them for that. Don't send them for a test. It's not going to do anything for you. Document your assessment as well, and make sure you send people ASAP, like that day. I can't tell you the number of times I've had clients call me and they say, I want to drug test somebody, reasonable suspicion, and I'll say, great, when did it happen? And they say, oh, last week. That's a problem, so make sure you do it right away. Obviously, safety is a consideration. If you have somebody who's a receptionist, do you really need to be testing them for cannabis or any drug for that matter? And in some places, you may have an issue with that. But again, we know there's accidents, there's performance issues, increased liability to the company. OSHA still hasn't spoken to this issue yet. The National Safety Council does recommend zero tolerance. Unfortunately, they don't, know all of the problems that employers are facing in some of these jurisdictions. And then again, keep in mind for safety sensitive, there's some jurisdictions, New Jersey, New York, and California, that just don't have any exceptions for those rules. So you have to be really careful. And sometimes it's a business decision to make in terms of what is your risk tolerance. Another consideration is the, how do you want to be perceived as an employer, right? We're reaching 3/4 of America supporting legalization at the federal level. And so is that something, do you want to be, do you care about your view in this, on this issue, I should say. Job market considerations. Do you have a hard time hiring? I've had some clients tell me, like, I can't hire anybody because everybody's testing positive. What do we do? And so maybe that's something that you all need to consider on your end. Duty to accommodate. Some companies, they find this to be a big pain and they don't want to deal with it. And so this might be something to consider or discuss when you're deciding whether to continue testing. Most jurisdictions, well, I shouldn't say most. So the slide that I showed you, and I assume you'll all get the deck with the bold and the underline under the medicinal, those are all jurisdictions where I would say that an employer has a duty to at least engage in some sort of an interactive dialogue if the person tests positive and they say, I'm a medicinal user. So Illinois, New Jersey, Massachusetts, there were a bunch of states up there. And we're seeing that because courts are saying you have to do that, but there are also some jurisdictions where the statute says that. So what does it look like if you're going to accommodate somebody's medical marijuana use? A lot of companies, especially their operations people, they'll push back because they think that just engaging in an interactive dialogue necessarily means you're going to have to accommodate the marijuana use, and that's not the case. All of the cases that we've seen published on this, all three listed on the side, on the slide, the employer didn't engage in any interactive dialogue at all. So engaging in an interactive dialogue is simply getting information and having a conversation with the employee, considering their job duties and deciding based on everything we know about your use, which you can find out from their medical provider, how often they're using, when, based on what we know about this job. We think that we can accommodate you because maybe the doctor has said that they only need to use before they go to bed. But if they say they've got to use all day long or what have you, which I've never seen in my experience, then clearly you're not going to accommodate that. So my recommendation is that, again, depending on your risk tolerance, just keeping in mind that there are some states where if somebody says they're a medical marijuana user, you're going to have to engage in this interactive dialogue, especially if you want to avoid litigation. CBD is causing some problems simply because the FDA still doesn't regulate it. And we're seeing situations where a product will say that it's THC-free or pure CBD, but in fact, there is enough THC in there for people to test positive for drugs. And so what happens is people will say, well, I use CBD, and then they'll go for a test and they'll test positive, and they're all very shocked about it. The company will reject them or terminate them. And if the person says they're using CBD, how are you supposed to know if they're on the up and up about that, right? So typically what employers do is they treat it the same as they would, because if it's pure CBD, it's not going to show up on a drug test. So if it does show up as a positive, then employers are treating it that way. Now, keep in mind, my recommendation is if somebody says they're using CBD for a medical purpose, maybe they're saying, they just need it to help them sleep or calm down at night, then my recommendation, if you're in a medicinal state, is to treat it like medicinal and then go ahead and go through that interactive dialogue. Virginia is the first state in the country to pass protections for CBD users. How are employers handling this problem? My slide used to say business as usual, but we're really not seeing that anymore. You'll note that even the first bullet is, I think, risky. I'm seeing, again, more and more employers are moving away from it, especially pre-employment and particularly for non-safety sensitive roles. In my experience, though, I am seeing employers continue to do it for post-accident, reasonable suspicion, random, in states where they're allowed to do so. And even there are some companies with large geographic footprints who just have different policies based on where they are. Sometimes I have one client that calls me, emails me, a couple times a week. Has anything changed here? No. Has anything changed here? No. Or if something new comes out, I'll let them know. And they have a state-specific approach that they've done that requires a lot of work. Most companies don't do that. But I think we're going to start seeing more and more employers move away from it. And that's not to suggest that that's right. I think that companies are just having a hard time dealing with it and keeping up with the explosion of marijuana laws across the country. Last two things I'll talk about, drug testing policies. Just keep in mind that drug and alcohol testing statutes and policy requirements do exist in a handful of states, particularly Boulder, San Francisco, Iowa, Minnesota, and California. Maine, you have to have your policy approved by the state. So if you're in the state of Maine and your policy hasn't yet been approved, you might want to look into that. Some of our policy requirements that we know about come from cases, not statutes. California, Massachusetts, New Jersey, and West Virginia don't actually have drug testing statutes. However, we know from case law the way a policy should look. So that's how we get that. Make sure you have a clear definition of illegal drugs. You want to make sure that it includes marijuana, because if you just refer to illegal drugs throughout and you don't define that, then you're going to have an employee who is fired for testing positive for marijuana in a state where it's legal, and they're going to say, but it's legal, your policy covers illegal drugs. So make sure that you're defining illegal drugs to include marijuana if that's what you want to do. And California requires that you have, this is the only jurisdiction, California requires you have a authorization for the release of medical info. It has to be in 14-point font. Don't ask me why that is. And that's because California is the only state in the country that treats drug test results like medical information. So just some final thoughts. If you're considering changing your policy or doing something radically different or keeping it as is, it's never a bad thing to have a conversation and just make sure everybody internally is in agreement about that and you're all doing it for the right reason. And then always consider the state where the employee is located or the job applicant. Make sure you know what those protections are. Keep in mind, can you even test? New York, again, a big thing. California, make sure you change your methodology to oral fluids. And stay on top of duties to engage in the interactive dialogue. It can be a cumbersome process, but once you kind of get the process in place and you have the forms and you train your people, it's really pretty easy to walk through. And then make sure that you have your policy set out so that your employees know what your expectations are and they know that your policy applies to marijuana and CBD. That way there's no confusion. So with that, I will turn it over to the audience for questions.
Awesome. So we do have some questions from the audience. First question is, my company hires people for work that would be very dangerous if they were high. Do I qualify for safety sensitive?
There are some jurisdictions that have specific definitions. There are very few, but I believe the general test is that if the person could cause serious injury or death, or depending on where you are, major property damage, if they were high while performing their jobs, then I think you have a really strong argument that it's a safety sensitive job.
Can I do post-accident for THC in New York?
No.
Okay.
I mean, New York, so let me clarify, New York Department of Labor takes the position you can't do any cannabis testing unless there's an exception. Reasonable suspicion, we're on the fence about. Post-accident, it's probably risky because at least with the reasonable suspicion, you have some indicia of impairment, but with post-accident, you wouldn't. I think it would be very, very risky in New York to do a post-accident THC test.
It's fine to continue using urine testing in California if we remove THC from our panel, right?
That is correct, except in San Francisco. Actually, in San Francisco, you can test for urine, but the San Francisco ordinance applies if you use urine for any other type of drug, and there's some restrictions on random testing and things like that. But yes, to answer your question, if you want to continue to test for other drugs and you don't want to test for THC, then you can stick with urine, or you could even move to oral fluids or hair for any of those other drugs as well.
If an employee smells like marijuana in California, can I send them for a reasonable suspicion?
So that's going to really depend. Ideally, you would want to have additional evidence of impairment. And sending somebody for a reasonable suspicion test isn't going to tell you anything. It's not going to tell you they used at work. It's not going to tell you they used during their break. So can you send them? Yes. Can you take action based on the positive test result? Probably not. So if you know that, then ask yourself, is it really worth sending them for a test under that fact pattern?
Got it. You talked about oral fluid testing being okay in California. Is that for pre-employment or randoms or both?
Yeah, so in California, if you're going to continue to test for THC, my recommendation is you move to oral fluids for applicants and employees. But keep in mind, there's risk in taking action against the result for a current employee. But yes, you would want to move to oral fluids.
Okay. Can you elaborate on the risk for a current employee?
So the risk is that since no test proves impairment and the law protects off-duty use, if you terminate somebody, even with an oral fluids test, they're going to go to the California Civil Rights Department and claim, well, I used the night before, and you're not going to have evidence to show that's not true. So that's the risk. The risk is it turns into fighting at the agency about whether or not the person was impaired, and you can't prove they were impaired because no test proves impairment.
Okay. And that goes back to your other point about document. If you have other situations that you can document and show more cause, it helps, correct?
Correct.
And that actually goes into the next question. How much documentation do I need for reasonable suspicion testing?
So I recommend just a reasonable suspicion checklist or worksheet. I've put it together. I've seen a lot of companies use one. The state of New Jersey has a sample on their website, essentially lists out, you can even have all the different types of indicia. You check some boxes, who the supervisors were, what you saw, the times, just a 2-page document. And it doesn't have to be a worksheet. You could write it all out as well, but you want to be able to just provide to whoever is suing you or any agency evidence that here's my evidence that we are not having to backpedal and put it all together. So there's no right or wrong answer here. Just make sure that you're documenting everything you see and heard and smelled and all that.
Okay, last question. And if we're unable to get to your question today, we'll reach back out to you after the conference. But you said no exceptions in New York and New Jersey for THC testing, but my employees are DOT covered. I can still test them, correct?
Yeah, so so New York does have exceptions. It's just they're very limited. So New York, DOT is always going to preempt all of these laws. So if your people are DOT drivers, then stick with DOT. But there is no general safety sensitive exception in New Jersey or New York.
Well, Jen, we've reached the end of our time here. Thank you so much for coming out and spending some of your time with us today.
Thank you for having me. I appreciate it.
Yeah. And again, everyone that joined us for our first day of Day with DISA, we're greatly appreciative of you participating, and we look forward to seeing you in more sessions throughout the week. Goodbye.